Hi, my name is Akiva Goldman. I'm an attorney with Goldman and Associates. A lot of our clients call us because they're on either end of a potential domestic violence case. As you may know, a domestic violence case is normally another assault and battery that occurs within the household, sometimes between husband and wife. Now it's called domestic violence. So in a situation like that, how do we win that case? How does a person charged with domestic violence prevail? Well, the charge itself is a criminal case. That means in order to be convicted, one must be proven beyond all reasonable doubt that the facts support the conviction. And that's a good thing. The bad thing is, it's not that hard to meet the requirements. You know, in order to be guilty of an assault and battery, in order to be guilty of the elements for domestic violence, you don't have to take a baseball bat to someone's head. Merely getting involved in a tussle could be regarded as domestic violence. And then it's a question, well, she grabbed me, I grabbed her, who pushed who? It's not so simple as to, determining, who's guilty and who's not. Certainly in cases where it's, kind of a mutual affray, those cases could be winnable on the basis that who is the one who actually caused it. Also, am I defending myself? Did I initiate it or did they initiate it? So these are the kind of things we look to. Many times, though, in domestic violence involving a husband and wife, somebody will call the police. Maybe it's one of the spouses, maybe it's a neighbor who heard a ruckus. And then the question is, now that the dust is settled, do we really want to go forward with it? In a lot of cases, one spouse will say, yeah, I just wanted her taken away from the situation. I just wanted him out of the house, but I really don't want him prosecuted. I need him. He's the only breadwinner in the family. What are we going to do? He's not permitted to come to the house now. There's a no contact order. So in situations like that, we see many times that the other spouse, despite initiating it, will drop off the face of the planet when it comes to further proceedings. And when that happens, when the other spouse will not participate, many times the court will dismiss that because they'll say, we don't have a complaining witness. Now, the court doesn't like to do that. The court's not happy about dismissing it. Worse than that, the court's not happy with you starting something that you're not going to see through. They're not marriage counselors. They're not there so you can jockey for position. They're there to protect people who are really being beaten. That's what it's for. So the court will tell you, if you tell them, I don't want to participate, I changed my mind about the prosecution. The court will remind you, this is not you against him. This is the people of the state of Michigan versus him, or the people of the city of Southfield, for example, versus him. You're just a witness. We don't need you. We can force you to come if you don't want to come anyway. We can send out a material witness warrant for your arrest. We do all sorts of things to compel it. The truth of the matter is, though, folks, in a lot of cases, the court won't do that. They may threaten to do that, but in a lot of cases, if you don't care about it, the court doesn't care about it. But mind you one thing, if you call multiple times and have your spouse arrested multiple times only to not show up, they're going to have a boy who cries wolf thing going on out there, and they may not respond to you later on. So you have to be very, very careful when you initiate these proceedings. If you have questions about this, reach out and we'll be glad to help you out. If you found this helpful, please like and share.